Hi friends, I am going to dictate you a legal matter 120 words per minute. If you like this video, please subscribe my channel and share to your friends. Let's start. 1, 2, 3, ready. This is an application under section 256 within bracket 2 bracket close of the Income Tax Act, 1961 stop. It relates to the assessment for the assessment year 1987-88 stop. In the assessment made on March 20, 1990, certain additions were made in the income of the assessee without affording an opportunity of hearing to the assessee stop. On appeal, the appellate assistant commissioner set aside that said additions made without affording an opportunity of hearing to the assessee and remanded the case back to the income tax officer for deciding the case of additions so set aside after affording an opportunity of hearing to the assessee stop. Aggrieved by that order, the assessee preferred an appeal before the income tax appellate tribunal stop. The appellate tribunal held that the additions made without affording an opportunity of hearing, being in contravention of the specific requirement of the provisions of the statute that before making any addition in the income returned by the assessee, the assessee has to be given an opportunity of hearing, renders the order void ab initio and nullity, which could not be cured and has only to be quashed and could not be made the subject matter of remand stop. Therefore, it allowed the appeal of the assessee, the additions made by the income tax officer were set at not stop para. Aggrieved by that order of the income tax appellate tribunal in appeal number 1132/JP of 1991, the Commissioner of Income Tax, Jodhpur, made an application under section 256 within bracket 1 bracket close of the Income Tax Act for referring the following questions of law said to be arising out of the tribunal's order stop para. Whether, on the facts and in the circumstances of the case, the income tax appellate tribunal is justified in law in holding that the order passed by the assessing officer was illegal and ab initio void for the reason that the principles of natural justice were violated by not affording an opportunity, para. Whether, on the facts and in the circumstances of the case, the income tax appellate tribunal is justified in law in holding that not giving the assessee an opportunity was an incurable mistake of law and, therefore, the Commissioner of Income Tax within bracket appeals bracket close was not justified in setting aside the assessment order for making afresh after allowing the assessee an opportunity, para. Whether, on the facts and in the circumstances of the case, the income tax appellate tribunal is justified in deleting the addition of rupees 11,283 made by the assessing officer on account of rental income from property in the Benami name of Sri Afroj, the minor son of the assessee, para. The said reference application RA number 126/JDH of 1998 has been rejected in respect of questions numbers 1 and 2 on the ground that the tribunal has decided the appeal after taking into consideration provisions of law in the light of decisions of the Supreme Court and therefore need not be referred. And question number 3, which was in respect of deletion of the addition of rupees 11,283, the tribunal refused to refer the said question on the ground that the property belongs to the minor son of the assessee and was not held benami, was a question of fact and does not give rise to the question of law. Stop para. We have heard learned counsel for the parties, and for the reasons to be stated hereinafter, we are of the opinion that the order of the tribunal rejecting reference application number 126 oblique JDH of 1998, holding that question numbers 1 and 2 are not questions of law, is erroneous. Stop para. On the first premises, the question raised is about the scope and ambit of the authority of the appellate authority to make an appropriate order and to direct rehearing of the case in case it finds an order not sustainable because of want of opportunity given to the affected party, comma, is not a question of fact but is a question of applying the legal principles about exercise of jurisdiction of the appellate authority in the matter of directing a remand or questioning an order. Stop. The tribunal also says in its order that the tribunal decided the issue in favor of the assessee by holding that the order of the assessing officer was ab initio void. Stop. In our considered opinion, the decision of the tribunal was based on the legal provisions and on the basis of the decisions of the apex court. Stop. The very fact that the decision depends on considering the statutory provisions and interpretation thereof suggests that the question sought to be raised and preferred to this court for its opinion is a question of law and not a question of fact. Stop.